Thank you, Mr. Chairman. We know that President Trump expects all of his nominees to be loyal to him, and with regard to his judicial nominees, he expects the same thing. So yes, we get these rote answers to simple questions. I asked the following two initial questions of all nominees before any of the committees on which I sit to ensure the fitness to serve. So I will ask these initial questions, starting with Mr. Flowers and then Mr. Schwartz. Please respond. Since you became a legal adult, have you ever made unwanted requests for sexual favors or committed any verbal or physical harassment or assault of a sexual nature?
No, Senator.
No, Senator.
Have you ever faced discipline or entered into a settlement relating to this kind of conduct?
Never.
No, Senator.
Mr. Flowers, while you were the Solicitor General in Ohio, you filed an amicus brief in a case called Brandt versus Pompo, involving the application of Ohio's cap on non-economic damages to a civil suit by a rape survivor against her rapist. Do you remember doing that?
I have a vague memory of the case, yes.
Yeah. So you filed that amicus brief in support of the rapist position, arguing that Ohio's law artificially limiting the amount of the survivor's damages for pain and suffering was constitutional, and the Ohio Supreme Court disagreed with you. I want to ask you, in your brief, you wrote that the damages cap, quote, protects against the risk that a jury presented with a suffering victim will award more than is necessary to fully compensate that victim, end quote. Can you explain why the jury verdict in that case of awarding $20 million to the rape victim was more, in your view, than was necessary to fully compensate her?
So, Senator, we never took that position. I filed that brief on part of Ohio, and the position we took was that the law was constitutional.
Can you speak into the mic, please?
Sure. The position that we took was that the law did not violate the Ohio Constitution. We never argued that the particular award in that case was excessive. All I was doing was my job, which was to defend the constitutionality of the law in question.
Well, you may not have argued that $20 million was excessive, but that was the effect of your argument. And frankly, the state of Ohio was not even sued in this case, and yet you decided that you should present yourself as Solicitor General and try to limit the award. So I can see where the state didn't have an economic interest in your position, but the people who did have an interest in it were the big businesses and insurance companies who love the limitations of recovery in these kinds of lawsuits. So rather than, you had the option of not weighing in. The state of Ohio was not a party to this lawsuit, and yet you weighed in on behalf of basically the rapists. So to say that you were performing your duty, I think you were using your discretion in ways that basically serve the interests of the business interests and insurance companies who didn't want to pay out $20 million. Another question. Last June, you wrote a post on your blog titled, "Some Thoughts on the Future of Textualism and Concerns About Its Timid Application." Do you remember that post?
I do, Senator.
And in that post, you addressed textualist judges, and you wrote, quote, "Timid textualism is not useful for those who wish to reverse, not just stop, the degradation of America's constitutional order and traditional Western values." Mr. Flowers, can you list some of the traditional Western values that courts have a role in restoring? And I assume that should you be confirmed, then you will be a judge. You will be a judge that will seek to restore traditional Western values in a non-timid textualism. So can you tell me what you consider to be traditional Western values?
Senator, one example of that would be freedom of speech. But I was not, to be clear, referring to my views. I was addressing the views of many young lawyers who I've heard express these concerns and based on those concerns, expressed skepticism about textualism. I was not advocating that courts set out to do this, and as a judge, as a circuit judge, I would faithfully apply the law and abide by Supreme Court precedent.
Well, you certainly give the implication that you would become a non-timid judge who would be seeking to restore traditional Western culture. And I would say those are words that do not necessarily talk about freedom of speech, which this regime is very busy trying to stifle, by the way. Thank you, Mr. Chairman.